Dr. Alexandrov and Mr. Kazmarek. And I will, it's just going to take one transition. I fully understand the question. But if one begins from the proposition that that relationship, right, is not, let us say, expressly disclosed, we think there was enough information there that it was disclosed given the CVs and the bios, but you have that disclosure, then you have the public information linking them. Once the challenges are made against Dr. Alexandrov on the basis of double hatting with an expert, with a quantum expert, it does not matter that it is not Mr. Kazmarek, because then even if they're saying, and again, you have to take the leap that the public know that your knowledge only runs from the time that someone else comes up with a legal argument that you could have come up with years ago, right? Because the first person that challenged, which was then Pakistan and TCC, they're relying on information that they learned about this double hatting relationship that Dr. Alexandrov had with the Brattle Group. And the issue there was when they learned of that relationship, and you look back to when that information became public. What other people are then doing is saying, okay, I have that same problem, but really, I didn't even know about it until someone else came up with this legal argument. And then that legal argument was reported in the legal press as a challenge. And then I thought, aha, here's something I can look into. And so I look into it and then I find, yeah, because he is a very prolific arbitrator, he deals with these quantum experts. I also have a problem here. I have found a relationship, so I'll make a challenge. And then you see these challenges. So in ISER, they bring it, but on the basis of his relationship with a different expert. Misen, you see a different expert. Here you see a different expert. But it is enough, even if you disregard, which we say, of course you can't disregard all the public information before about the cases and the relationship. Once all these challenges come forward, it doesn't matter that it's not with Mr. Kazmarek, because anybody would know at that point in time, he's being challenged based on double hatting with an expert. If you deemed that to be problematic, you would simply look and see, who's our expert? Kazmarek. Let me check. Do they have any overlapping cases? You would have instantaneously found, or you would have asked him. You would have said, look, do you have any cases with Mr. Kazmarek in the past X years? And then you would have gotten your answer. So that's why we're saying it doesn't matter that these challenges aren't against Mr. Kazmarek particularly.
Yeah, but would it be a clear line if there is one between Mr. Kazmarek and Mr. Alexandrov? That would be a clearest line, right?
Perhaps I think it makes little to no difference whatsoever. I think that at this point, if you even came again to say he wouldn't have even known at the point of the challenge, you're already, I believe that it's gravely mistaken, because you're saying that a party, let me put it this way, it's the underlying relationship that's problematic. If that information is in the public domain, if you knew or should have known, then you have to bring a challenge soon after that. You can't wait and say, we didn't think it was problematic. We could have.
Okay, I understand your argument.
And then someone else comes up with a legal argument and say that legal argument is your new fact, and then do it. But even hypothetically, if we were to consider that to be the new fact, this has got to be enough, because then you're looking at someone who is bringing a challenge based on that legal argument. Yes.
I think you're guilty of the same repetition of which I...
Okay.
Yes.
Thank you. Is there any point in the questions that you'd like us to clarify? Do you have is there anything that you don't think is clear enough and you want to use this opportunity to clarify?
Are you talking about this question or any other question?
All questions now.
Well, for that, we will request, enough time. We have noticed things here and there. I would not be prepared right now. And there might be also inconsistencies in between. I think that there is a Spanish version and English version. No? Only English?
Okay. Only in English. I'm so sorry.
Okay. Someone has a in my team a version in Spanish somehow. It might have been translated for the sake of someone. Anyways, we will write back to you. I mean, if we have concerns about the question. So at this point, I'm not in a position to quickly respond to.
Okay, Ms. Menaka?
I have one question. It's not on the content, but I see that a lot of the questions, for instance, even question 1, you call for examples of situations or case law, other places you ask for jurisprudence. In answering these questions, we would like to introduce supplemental legal authorities if it's in direct response to your question, particularly if the issue hasn't been briefed. They may not be on the record. So I wanted to make clear that that was your expectation and that is permissible.
Let us hear the other party, because perhaps they too wish to include more.
I was conferencing with my colleagues here. I didn't hear what it was said. I mean, let me read the transcript then.
I can briefly just respond that in light of the questions where the committee is asking for examples or case law or jurisprudence, some of these are questions that have not been answered in the parties' briefs. And we would then expect that we would need to offer supplemental legal authorities that are not currently on the record in order to answer those and or to, elaborate, like you ask, for instance, for promptly what has been the longest term allowed. And we have lots of jurisprudence on the record, but if we were going to take, a survey to say the longest, it might be that we introduce a new legal authority.
I think Guatemala had a similar concern a couple of days ago.
Yes,
right?
and the answer was no. We thought that it was only the information that is in the record. So what I suggest is that, again, I will not respond to that right away. I will take my time. I will look into this issue and whether it could be appropriate to use legal authorities or not. At the end of the day, it's going to be in the hands of the annulment committee to decide.
Might a way of dealing with this be for leave to be sought for additional authorities to be used and an explanation provided as to why those legal authorities are sought to be deployed? And either party can do that. And then the tribunal decides whether to grant leave or not. Would that be appropriate?
Normally, Professor Jones, I have no concerns with legal authorities being introduced. In this case, this issue has been that problematic that I really would like to consult with the authorities, to consult with my client before I can respond. Normally, in my person, I'm not afraid of the legal authorities, though this cannot be my position. It has to be the position of Guatemala in a situation in which the entire thing is being dealt so egotistically that we don't want some information to be.
All I'm suggesting is
I understand what you're suggesting.
No new legal authorities without leave, and leave has to be sought to explain why it is needed. Then either party has the right to make an application and the tribunal will decide on the basis of that.
Or the committee in this case. So it seems like a sensible approach. If you already know, if you identify a number of cases that are relevant for answering one of the questions, you write to the committee and say, we have identified 3 cases that are responsive to question 5, and we would like, and this is a new question and it had not been brought up earlier, and this is why we could not have filed it before, and these are the reasons why we want to file it now. And we will hear the other party, and perhaps they too, they agree or they not agree, we don't know, and then we will take a prompt decision. And this, yes, of course, Lawrence.
It might even be simpler if both of you can agree on which question that you will think you require legal authority, and that's it. So that there won't be further need for us to consider applications. This procedure is actually in our procedural order, so it's not new. So if you can agree on which particular issue there you want to, both sides want to put in additional, then so be it. Minimize applications.
It may happen that once you have the chance to go through the questions and you relax and you get some sleep, and then you may, talk to each other and say, what do you think? Are these questions, do we open the gate to new? I don't know. If you can agree on things, it's always welcomed by the committee. If you don't agree, then you make specific submissions for us to give leave to submit new evidence, and we will see what we do. Legal authorities, I'm saying, as evidence.
And just for the avoidance of doubt, if we were to make that, is it sufficient to say we would like to submit, XYZ case for question number 1, for instance, or do you want us to actually then state why those cases are relevant to question number 1?
Yes, please do provide a couple of sentences so that we understand that
That's perfectly fine. I just don't want, because then one party may consider that then you to be using it and briefing before having that admitted to the record. I just want to be absolutely clear. What is the scope of the application? So
I'm sure we will all be reasonable.
Okay.
We've been so far and we will continue being reasonable. Thank you.
Agreed.
Any other question?
No, thank you.
Any other question?
We don't have
No.
questions.
Good. So let us then please agree on a reasonable time period for the filing of these answers to the questions, and perhaps also a limit to the length of these answers. Just something like a range of pages, so that we don't end up with 200 pages, and I don't mean who's going to be filing 200 pages and 15 on the other side. So what do you think? And
I did have one other question.
Okay.
Now that,
okay,
since we're talking about pages, are you anticipating then the post-hearing briefs are limited to answering these 24 questions, or like what is the scope? Is that the limit, or does it go beyond? And if so, to what extent?
I think
We are not proposing any post-hearing briefs. We're proposing only answers to questions.
answers to the questions. Yes. So it's answers to the question. It pretty much covers, I think, most of the areas that have been, and because early in the morning, we covered lots of things about the award and the inconsistencies. So this covers.
No, that's
the
a
rest.
big clarification. So
Is
Yes,
there
so
any
very-
area that you would have expected to have been given the opportunity? Because I mean, we don't to impose a strict limitation. There's something that you would like to have addressed. I think we covered
very
almost
thorough,
everything, but
so-
it's
okay.
We would like to have some room for some things that might not be contained in the questions put by the committee.
such
like-
as
Nothing that comes immediately, unless my colleague would like to elaborate on that. But maybe, I mean, just to give the parties the flexibility to have some.
tell us now, please. Mr. Gosses.
Just briefly, if we were to include the 2 questions which we addressed earlier, which are not part of the 24 questions, the issues of the code of conduct, the issues of the inconsistencies, which are not specifically addressed in this 24, but were among the 2 questions we received yesterday, that would probably cover everything out. If this is only limited to these 24 questions, those are areas, especially the inconsistencies and the
But you did
arguments,
provide an answer, right? I think I've written it down somewhere that you said, or it should be in the transcript if I hadn't. You said it was on the second, my question is regarding, what was it, Rule 10A6? Was it 6? I think it was 6. Since when this was part of the draft, and you said since the second version, but then you came and said this was since, I think you said something 2020, but I'm not, should go back to the transcript to make sure, but you did provide an answer.
I was referring specifically to not the issue of the code as much as the issue of the inconsistencies on the reasoning in the award, the arguments by TECO that we heard, to have a chance to comment back on that. and what
I
we
think
had
you've
today.
had more than ample opportunity to address that. And we know, I mean, we've got both parties' submissions in writing. They're really excellent quality. And I've seen that we have been through them, read them, and we're well aware of what the parties say. So I don't believe that the committee needs further briefing on that. So let's stick it to the 24 questions. And I believe there was a specific answer they used about since when this wording is part of the drafting procedure, since when is this something that was discussed? And I think you said something, and then you came to me and you
For
said
that,
even
there has
earlier.
been a very specific question, and it is a response, and it is on the record.
It is on the record. I
Yeah.
think it's on the record. Yes. Good. So let's go back to the initial question, and it's what's a reasonable range of pages to provide a proper answer?
Would the annulment committee provide us a guidance on what it would be reasonable for the annulment committee?
What would be? What do you think? I mean, the submissions are really, really long, and there's a lot of repetition in them.
We have to divide it up by questions, don't we? We can't give you a limit to the total amount of pages you'll devote to answering all the questions. So why don't we say 3 pages per question?
And we could give a total amount of pages.
It's
But
you've got I mean, there's 24 questions. Some are direct addressed to one party, some to the other. I mean, it's TECO's examples on situations of 52(1)(a). I mean, it's their submission, and they must have some idea of what that is intended to, what situations this is intended to apply according to their interpretation. So I don't know. And would you say 50 pages? Would that be something reasonable?
Well, if I-
be per question.
Yeah, I was more inclined with the number that Professor Jones suggested. I would like at least to be 100 pages.
100 pages.
Yes, I think otherwise for 24 pages, 50 pages is going to be too short.
You say 100.
The
What do you
problem
say?
is if you get 100 pages and you decide to do half a page on all the questions except one, we'll get a whole pile of crap on the one you choose to spend a lot of time on. And this just doesn't make any sense.
Well, you said 24, 3 pages. I mean, there are 24 questions, 3 pages per question. I mean, that brings us closer to 85.
Yes.
Yeah, but
So the thing is, all of these questions are important to the committee. If you choose not to answer an important question, it's your choice, but it's not advisable.
Let's do 75 then. If that is,
we
it's
hear
a number
70.
that you can live with.
Ms. Menaka.
I have 2 questions.
Yes.
First of all, I do prefer, I think that it makes sense to do it per question for the reasons that, you've expressed, because if we just have a limit and it's limited to the questions and you've already said we're not supposed to add extraneous things, so that would be my preference. But I do have a question in that regard because
Yes.
some of your questions, for example, 15, you end by saying the committee is clear on TECO's position, wants to hear Guatemala's views.
Yes.
So on that question, for example, would you want us to skip it? Would you want us to briefly summarize our position?
It is not expected that you provide an answer. If you wish to provide an answer, you're
Okay.
welcome. But this is one of the examples where I think one question was more addressed because we have clear what one party says.
Sure.
We'd like to have a sort of reply by the other, because it's not clear to us what the other party thinks.
If I may suggest, it might be even better if you go by the different sections. Yeah, because we categorize them in different sections. So you decide which of those questions you want to tackle more and less. And because there are 6 sections there.
Yes.
So just
So,
7 to 8 pages a section or whatever it is.
Although
you
one-
were working 2 months on your submissions. We worked 2 hours on these questions. These don't mean to be a straitjacket.
Yeah.
Okay. But this reflects our concerns, our areas of concern. So in to the extent it is possible, please follow the logic that is there. Don't feel you're in a straight jacket and you need to answer all of them. You've got some freedom, of course, and liberty to address them as you see fit. And please make it something. I don't want to impose a limit of 3 pages per question. There's some liberty in there, but also try to have it something that's consistent, that you cover everything, because we'd like to have an input on everything.
Some questions, for example, can be a yes, no.
Yes,
Yeah.
exactly.
It's
Yes.
Exactly. You
so
ask if
that's
there's
why
been
sections. Yeah.
any jurisprudence on X.
Then
and-
do we have an agreement on the number of pages or
I
not?
think 75, Ms. Menaka, is that acceptable? If you want to have it, make it shorter, you will.
75 is fine.
75, excellent. The font can't be smaller than Times New Roman 12, please,
Yes.
for my eyes' sake. Good.
Understood.
The time. How much time do you need? I assume I don't know if we've agreed on the time to review the transcript. Okay,
I think that the procedural order says 20 days.
is that still, oh yeah, I remember you had another hearing that we decided
We have-
20 days, is
We
that?
have another hearing next week.
Yes,
We had a hearing before, and we have a hearing with Ms. Menaker on 29th August.
well,
So we
just
have a very
shows
full
how
plate
successful you
here.
are. So,
Yeah. And how much we will need to work during the summer as well. But
I hear you.
yeah, no,
It's no different here. So it stays 20 days?
we would like that, yes.
Yeah, Ms. Menaka, 20 days that's what was agreed. And then
For
for the revision,
the revision,
to
yes.
review the
To review-
transcript. And
yes.
we've learned how important that is. So
Yes.
please do check all the figures. So, and now the real important time period is how much do you need after you have reviewed the transcript to produce these answers to the questions?
Any suggestion?
You may wish to turn off the mic.
Mhm.
Mr. Tortorola, you may wish to turn off the mic. So Dr. Torterola, do you,
Well, yes, I would like to hear, if possible, from Ms. Menaker first. I mean, if she can suggest a date, so we avoid a fight. Maybe they are as busy as we are. Otherwise, I will go with my proposal, but maybe if she would like to volunteer first.
would you like to volunteer first?
Sure. I did have one minor question. The table that you had asked for the cases, and that was limited to the record on the timeliness, we have been working on it. It was not in condition to produce today. Would you like us to make that as an annex to
Yes,
this?
but please.
Is that okay?
Yes.
Okay.
Yeah.
Annex it.
So we would propose also based on just schedules and such, Monday, October 4th. Oh,
If
is
we-
it? My calendar used to start on Sunday. Now it's- Oh, it's Monday's apparently the 3rd. So Monday, October 3rd.
One Monday after, and we have an agreement.
One more week,
One more week, yes.
one more week, would that be acceptable?
That's the 10th. Okay.
10th of October?
Yeah.
Excellent.
Okay.
With this, I think we reached yes,
No,
Mr. Torterola?
Yes, Madam
Yes.
President. We had the request to have a shorter second round. That it can be 15 days after. And as long as you wish, to the extent that we have the minimum space to write something meaningful and nothing else. I mean, like something 15 days after. I think
Ms.
it,
Menaker,
So I think that if the parties make the application to put in the new legal authorities, if any, beforehand, there will be no surprises because we're limited to the record, the argument we've been making. The other side will be on notice that those legal authorities, if admitted, will be used. So I don't see the necessity or advantage of having a reply, and certainly not setting with the expectation that we would have a reply now.
why don't we set a limit also for these applications?
That's
Because
exactly-
we don't want them to arrive like at the 11th
don't-
hour.
Yes.
So
I'm not concerned, as I said before, with the length of the legal authorities applications. I mean, if that is the issue, some of the questions are the first time that we are confronting them. And